I'm Judge Puffenberger of the Lucas County Probate Court. I'd like to discuss representing yourself in court. Absolutely, you're allowed to represent yourself in court. Everyone has the right to represent themselves. We call it pro se. You are appearing pro se by yourself, and you have a right to do that in any case. You should know the magnitude of the case and the complexity of the case. Some cases are just too complex, really, for an individual who's not trained in the law to be able to present. Also, you need to know what's my upside, what's my downside, how much can I lose here? If it's very significant, you should probably talk to a lawyer, because the law is complicated, and if you stand to lose a substantial amount, you should have an attorney. You will have the same responsibilities as any attorney in the courtroom. You will need to file documents, you will need to present your evidence according to the rules of evidence, and you are able to argue your case. The court will not treat you differently. You'll be treated the same as an attorney would be treated. Our website, lucasprobate.org, is a good resource for forms and information about how things work in our court. You need to know that all courts work differently, and the local court that you appear in may have different local rules than another court. No, the court staff may not answer your legal questions. The court staff may assist you in different ways. The court staff may explain procedures to you of how things work. They may provide forms for you. They cannot fill them out. They cannot explain to you how you should present your case. But they can explain to you how the system works and the specific case that you have, what will be expected and how that case will proceed. I think the most common mistakes that self-represented people make in my court are mistakes that are made because they don't know the rules of evidence. And if you have, for example, an exhibit you'd like to present to the court, you need to bring that to the court, and you need to be sure that it's something that's admissible in the court. I've had people in court tell me, well, I signed this document. Well, they don't have the document. Well, you need to have that with you. So it's a mistake to not have all your evidence with you. And people have tried to testify to things that courts deal a lot with documents. We prefer to have documentation rather than oral testimony. So if you have documents that pertain to your case, you should bring those to court. I think that's the most common mistake that I see. Well, there are different deadlines in all different kinds of cases. And when you undertake a case, you should look at the local rules, and basically you're required to be an attorney. And as I said, some of these cases are kind of complicated, and sometimes the time frames are complicated, even for trained attorneys and for judges. So you would be required to know all these time frames, and the court is not going to help you with that. You can find the local rules at lucasprobate.org, and then the rules of evidence that pertain to all courts in Ohio can be found at the Supreme Court of Ohio website. If you want to submit evidence and you do not have an attorney, let's say, for example, it's documentation, you should bring copies of that for the opposing counsel and also for the court, and that needs to be marked by the court reporter, and then you need to present that to the witness if you'd like the witness to testify about that document. If you're talking about witnesses you'd like to appear on your behalf, you may need to subpoena them. We have subpoena forms at our court that our court can provide for you. If you want somebody to testify on your behalf, you should issue a subpoena for them to be here. It's not harder to win a case if you represent yourself. Your evidence will be considered by the court just as the other side's evidence. The tricky thing is to get it admitted into evidence and know what is admissible, what it's not. Everybody's heard about hearsay. Hearsay evidence may or may not be admissible in different cases. So there are rules that apply to that, and you'd be required to know those rules. That would be difficult to do if you're in the middle of a trial, because it would be hard for an attorney to get involved once there's been evidence presented and that attorney has not heard that evidence. That would be very difficult. But if you come to court on the day of trial and say you want an attorney, the court will consider whether or not that's a reasonable request. But if you want an attorney and you decide that before the trial date, you should certainly let the court know that in advance so other parties aren't inconvenienced in being here when we're not going to proceed to a trial that day. The court will normally grant you a continuance to obtain an attorney. I would explain the procedures for sure during a hearing. I would tell you how the case needs to be presented, who presents their evidence first, who goes second. You may be entitled to have rebuttal evidence presented. I will provide you the information on procedures. With regard to the law, you should research the law before you get here, and you should have copies of the law yourself. There certainly is. If you have an uncontested case, and in the probate court, sometimes we get things that are very simple and no one is arguing about it, it's no problem. For example, someone passed away and there's a car worth a small amount and everyone agrees what to do with the car. You know, you can probably do that paperwork and file that without an attorney. If you come down and you're an adult and you want to do a name change, you know, and no one's contesting that, you can probably do that by yourself. And our court can give you some assistance when something is not being contested. If something is contested, the court cannot assist you at all on procedures or how it works. But a lot of the small things we do here that no one's opposing, we can certainly be of assistance there. If you contact our court and indicate that you'd like to obtain an attorney and you don't know what attorney to obtain, our court will normally refer you to the Toledo Bar Association, when the Toledo Bar Association give you information on which attorneys have expertise on different types of topics, and they could recommend a lawyer for you. The court itself cannot recommend an attorney to represent you. You have the right to represent yourself in court, and there are some matters where you can do that quite well, but when you get in a contested matter, it can get complex. I would advise you to have an attorney if you have a contested matter that's somewhat complex. But if you have a matter that no one's arguing about, no one's contesting, and it's fairly a simple matter, you may be able to handle that yourself without an attorney.